to us about judicial review, because that's just amazing, isn't it, Oliver? Judicial review.
Well, I think so, but I'm biased, of course.
No, we love judicial review. It's a very important choice, isn't it? So yeah, so for people who are new, we're going to use the chat box, get comments in. I think actually the more sessions we're doing, I've got to admit, the easier is it if you put your questions in the Q&A. I've got to admit that would be helpful. If you don't know how to use the Q&A, it's fine. Stick in the chat box. I will be checking them and I'll make a note for Oliver at the end. If you can't use the chat box for whatever reason and you'd like to ask a verbal question at the end, either drop, well, I think the easiest thing is if you raise your hand and then I'll unmute you at the end of the session. So other than that, it's with absolute pleasure I'm going to introduce Oliver Carter, who's a solicitor in the public law team and human rights team at Fairway Mitchell. And oh, Oliver, I need to give you the control of the screen, don't I?
I think so. That'll be helpful. And do you want me to share my screen then straight away with the presentation?
Well, if it's got the presentation on it,
yeah.
That'd be great. Okay, over to you. Enjoy.
Super. Thank you very much. So hopefully, everyone, I'm now sharing my screen. Kate, can you just confirm that?
Perfect. Yeah, exactly the way it should
be. You've got the first slide, which says using judicial review as a tool of systemic change.
That's the one.
Brilliant. Great. Well, thank you very much, Kate, for the introduction, and thank you all for joining me. I'm coming to you from a slightly dingy basement room in North London, so I apologise for that. Obviously, it would have been nice to all be together in the same place, but I understand Joe Biden is running most of his campaign for the United States presidency from his basement in Delaware, so hopefully you'll forgive me for coming from my basement to you from North London, as I said. So I'm here to talk to you about using judicial review as a tool of systemic change. And I don't know how much all of you know about judicial review or how much experience you've had of it, but hopefully by the end of this session, I'll have demystified it and told you what you need to know as advocates about judicial review. So just trying to go on to my next slide, but I don't think it's working. 1 second. There we go. So this is my plan for the session today. This is what I'm going to look at. My aim is to speak for about 25 minutes or so on what is judicial review, the grounds of challenge that you can bring in a judicial review, so the types of legal arguments you can make, the remedies which a court can give, so what can a court do for someone who brings a judicial review, and also about the process. So 25 minutes or so on those 4 headings, and then hopefully around 10 to 15 minutes on some case studies to try and give you a bit more of a practical insight into judicial review and how it can help individuals, campaign groups, charities, etc. to obtain justice. And then hopefully that will also leave me some time for Q&A and to take your questions, because I know some of my other colleagues have spoken at this this conference over the course of this week, and I think there have been quite a lot of questions, quite a lot of engagement. So hopefully that will apply to my talk as much as it has to everyone else's. So I thought I'd start, I've been following the Twitter feed, or parts of it at least, from Kate during this week, and I saw this quote from an advocate called Heather, which really resonated with me, and you know, I just loved it. So what Heather said, hopefully you can read it, but what Heather said is, I'm an advocate because not all people can advocate for themselves. The current political climate is stacked against the vulnerable. Even as rights are eroded, everyone should be able to access what they need and are entitled to, even if they do not know or cannot articulate what that is. I do what I can to try and make that happen. And those are the reasons I became a lawyer, and particularly a lawyer doing public law and human rights, a lawyer acting for individuals against the state, against public bodies. And I think the main difference between me as a lawyer and many of you as advocates is that the part of the advocacy journey that I'm involved in is a very small part of it, where there's a legal challenge or dispute. But I see my role very much as the way Heather's described it, to advocate for my clients, to try and protect their rights, to do what I can as part of that process. And where I work with advocates on cases, it's very much a teamwork approach to try to achieve what the individual person wants to achieve. So, as I said, I'm a solicitor in the Public Law and Human Rights team at Irwin Mitchell. Despite the name public law, including the word public in it, I think generally people don't have a great understanding of what it means. And quite simply, public law is the part of the law which governs relationships between people and the state, and which governs the conduct of public bodies. So that's public law. It can be very, very broad, but it includes, of course, things like the health duties on the NHS, social care duties on local authorities, the activities of government departments, many of the activities of police forces, and a lot of other sort of agents or bodies of the state. And public law, broadly speaking, requires public bodies, as my slide says there, to act lawfully, rationally, fairly, and compatibly with the human rights of people who are affected by their actions. And it can also be referred to as administrative law, but broadly speaking, that's what public law is. And there's a quote here from a former judge, Tom Bingham, who wrote a book called The Rule of Law, which really sort of encapsulates what public law is, as I said on that previous slide. So public law requires that all ministers and public officers at all levels exercise the powers conferred on them in good faith, fairly, and for the purposes for which the powers were conferred, without exceeding the limits of such powers and not unreasonably. If I was to recommend reading any book about law, which I can understand not all people may want to do in their spare time, but any book about law, I'd probably recommend The Rule of Law as a starting point that explains how the law sort of governs our society from very sort of first principles. And judicial review is really the process of challenging public law decisions, the process by which the courts review the lawfulness of decisions and acts by public bodies. So it's a practical means for people of enforcing the rule of law, that principle that everyone, including the government, including local authorities, police, the NHS, etc., are subject to the law. And those final 3 bullet points there, that's really sort of explaining the separation of powers between Parliament, which legislates to make the law, the government, which governs in accordance with the law, and the courts, which interpret and apply the law. So the government, like you and me, is still subject to the law, and they have to comply with their legal duties. Otherwise, they can be taken to court through judicial review, and the courts can then interpret, apply, and adjudicate disputes between people, between the government and people, etc. So the process of bringing a judicial review, well, it's an application to the administrative court, which is just part of the High Court, really. It's brought by what's called a claimant. So that's the person bringing the claim for judicial review. That can be an individual, as I've said, a group of people, a charity, a non-governmental organisation, a campaign group, a company, etc. And it's brought by a claimant against a defendant, or maybe 2 or 3 defendants sometimes. And defendants in judicial review cases are public bodies such as government departments, local authorities, NHS trusts or clinical commissioning groups, police forces, or in some circumstances, companies which exercise public functions. So where a public service is outsourced to a private company, then in the way in which it's exercising those public functions, that company could also be subject to judicial review proceedings. And when a judicial review is brought, there may also sometimes be interested parties or interveners, who have an interest in the case or have specific expertise that they can bring to the court to assist the court in making a decision. It's important to say that judicial review is generally a remedy of last resort. What that means is that if there's another effective method of challenging a decision, normally you'll be expected to use that method of doing so unless it won't provide a sufficient remedy. Now, that's not to say that you shouldn't seek advice on judicial review, but it is to say that the courts will only usually rule in favour of a claimant in judicial review if it was the best way, the only way really, of them challenging the decision. So I've listed there some examples of alternative ways of challenging decisions by public bodies. So there might be a specific right of appeal to a tribunal, such as in individual welfare benefits decisions, that the person can make an appeal to the first tier tribunal and will be expected to do that if there's a dispute about their entitlement to universal credit, for example. There may be a complaints procedure that the local authority or an NHS trust or CCG operates, and if that would provide a sufficient remedy for a person as an alternative to judicial review, then that complaints procedure should normally be used. But there are, of course, urgent cases or cases where a complaints procedure can't provide the outcome that a person is seeking. And finally, there are ombudsman schemes. So many of you may be familiar with the local government and social care ombudsman or the parliamentary and health service ombudsman. Obviously, if you've exhausted a complaints process for a local authority, you can then go on to the local government ombudsman. And the ombudsman in particular does have that can perform a very useful role where there are complaints or disputes about social care, and they can make recommendations which local authorities should follow. They're not absolutely mandated to follow recommendations by the local government ombudsman, but they need a good reason not to. And in my experience, usually they do. One of the great benefits of ombudsman schemes is that they're cost-free, effectively. You don't need a lawyer to engage in them, although we can assist clients with complaints to ombudsman. But sometimes they can be a better means of resolving a dispute, resolving an issue, than judicial review. So it is important to bear that in mind when you're considering a problem that a client has, what the best way of resolving it is, because it may be that it's via an ombudsman. And just on that point about rights of appeal to tribunal for welfare benefits decisions, I've said there for individual benefits decisions, if it's a challenge, for example, to a government policy concerning universal credit or another welfare benefit, then the appropriate route to challenge a policy is likely to be judicial review rather than going through the tribunal system in what is an individual complaint about that person's individual circumstances. And so, again, to provide some context, I suppose, of what judicial review is, it's been in the news more in the last year or two than it probably has been ever, because of Brexit, effectively. So you'll see these front pages here from the Daily Mail, the Sun and the Guardian about two cases which started as judicial reviews in the High Court and ultimately both went all the way to the Supreme Court, which is the highest court in the UK. The first case was about Article 50 and whether the Prime Minister at the time, Theresa May, had the power to notify the European Union that the UK was leaving the EU. And the court in that case decided that Theresa May didn't have that power on her own and that Parliament needed to authorise that power. So that was a judicial review against Theresa May as Prime Minister. And again, with the prorogation case against a different Prime Minister, Boris Johnson, that case was about the limits of the Prime Minister's power to prorogue Parliament. And in that case, again, it went all the way to the Supreme Court, which ultimately found that the Prime Minister acted outside the limits of his power to prorogue Parliament. So two very, very high profile judicial reviews which made front pages, but most, and the vast majority of judicial review cases don't make the front pages or may not even make the news at all. They may be sometimes reported in the local press, but often they're really only of interest to the individuals concerned. But nevertheless, because of these high profile cases, the government is looking at potential reform of judicial review. There's a panel which has been set up by the government to consider potential reform of judicial review. So we'll have to wait and see what that panel does, but it does seem the government's probably motivated by the types of high profile cases you see here, rather than the more regular judicial review cases on behalf of individuals against local authorities or against police forces or NHS bodies. And many judicial reviews are, as I said, brought by individuals in relation to health and social care provision, their immigration status, their housing, those kind of issues. But those individual cases can also have a wider or systemic impact, particularly where they challenge a decision or a policy which affects a group of people, not just the individual in the case. So who can bring a judicial review? Usually it will be an individual, or maybe two or more individuals who are affected by the decision at hand. Sometimes they will have support from what's called a litigation friend, such as a family member or an advocate, if they lack capacity to litigate. And that's not infrequent in my cases, where we're acting either for children or for adults who lack capacity, that a family member or an advocate provide instructions on behalf of the person themselves, where they lack capacity to litigate. But also cases could be brought by organisations such as charities, NGOs, campaign groups, or companies. As I said, the key test is whether the person bringing the judicial review has sufficient interest in the issue. Normally, in 99% of cases, that's not controversial, because a person will be directly affected by the decision or the act of a public body which they're seeking to challenge. But there are cases in the margins where, particularly where it's brought by a charity or a campaign group, they might have difficulty showing that they are themselves directly affected or have sufficient interest in the case. But public lawyers and human rights lawyers can advise on that issue. Now, funding. How can you fund a judicial review? I understand that there were some questions about this in a seminar yesterday given by my colleague James Betts, and this is a difficult issue, and it's of course an important issue. The vast majority of judicial review cases which I work on are funded by legal aid. Legal aid's available for judicial review, but is subject to a means test, a financial means test, and a merits test. Now, when legal aid was first introduced, really for civil cases, non-criminal cases, in the immediate post-Second World War years, as the welfare state was expanded and as people had more interaction with the state, with public bodies in relation to social care, healthcare, etc., around 80% of people were financially eligible for legal aid at that time. It's thought that around only 20% of people are now financially eligible for civil legal aid because of the income and capital limits. I've linked in the presentation here to an eligibility key card, which the Legal Aid Agency produces as a summary of eligibility for legal aid. But where people own their own home or have a significant income from their employment, it's rare that they are eligible for legal aid. It's not impossible, depending on the value of their home and what their income is and what their expenses, their outgoings are. But that's something that needs to be looked at carefully. But most of my cases, as I said, are funded by legal aid. They're either for children who don't have capital or income of their own, or for disabled adults very often who are in receipt of benefits and don't have significant income. And there are certain benefits which are passported for legal aid, which means they automatically pass the income test if they receive a certain benefit, and a number of benefits that, such as universal credit, income-related job seekers allowance, or employment support allowance, will passport the person for the income element of the legal aid eligibility test. So, as you'll probably gather from that quite long explanation of a short bullet point there, the legal aid eligibility test for financial eligibility is complicated, and probably you need to speak to a lawyer about whether a person is going to be eligible for legal aid. There's also, as I said, a merits test, which essentially means that the legal aid agency will not fund a case unless it has more than 50% prospects of success. So we as lawyers will need to be saying to the legal aid agency, we think this case on behalf of Joe Bloggs has a better than 50% chance of being successful at court if we go all the way to the High Court. And if the legal aid agency agrees with us and Joe Bloggs is eligible financially for legal aid, then it will fund the case. Importantly, what legal aid also provides is protection against adverse costs if the case is lost. Now, that's the risk that if you lose a case, a judicial review case, after bringing it to the court, you would normally be expected to pay the other side's legal costs as well. So the usual rule is that the losing party pays the winning party's legal costs. But legal aid provides protection against that for obvious reasons, because if a person is financially eligible for legal aid, then they're very unlikely to have the financial resources to pay the costs of the other side if their case is unsuccessful. So that's important in terms of access to justice, and that's why the vast majority of cases that I work on as a public lawyer are funded by legal aid. Because if a person is funding the case privately, or if, for example, they're crowdfunding the case, they still need to make provision for the possibility that if they lose the case, they may have to pay the costs of the public body, the legal costs of the public body. And that if a case goes all the way to the High Court and you have a hearing in front of a judge, that the costs of the defendant, the public body, could be £20,000, £25,000, £30,000, and that's just the other side's costs. That's not assuming any cost for your own lawyers. So for privately funding individuals or companies, charities, campaign groups, judicial review can be very expensive. Crowdfunding has become more of an option in recent years. I've mentioned a particular website there called Crowd Justice, which is set up to crowdfund legal cases. And a number of high-profile cases in recent years have either partly or wholly been funded by crowdfunding, which is essentially a virtual whip round saying, I have this case that I want to bring, please will you donate some money towards it? So when the junior doctors had a dispute with the government about their changes to their contract, they sought funding from members of the public on the Crowd Justice website. Likewise, some of the Brexit-related cases brought by Gina Miller and others were funded through crowdfunding, either in whole or in part. And that can help in some cases, particularly where there's either a big public or media interest, or where there might be a local campaign about a particular issue where a smaller number of people, maybe dozens or maybe 100 people, might want to contribute to a legal case, but individually none of them would be able to risk £20,000, £30,000 or more, but collectively they might be able to all put in some money to fund something. So those are some options for funding a judicial review case, but as I said, most of my work is legal aid funded, and that means the person I'm acting for isn't paying for my time, and they're very, very unlikely to have to pay the costs of the other side, the public body, if the case is unsuccessful. And I can answer any more questions about that when we have a Q&A at the end. So key questions really for us as lawyers when we're looking at a potential judicial review, we're looking at who made the decision which our client wants to challenge, when was the decision made, what is the impact of the decision on our client and potentially on other people as well, how was the decision made, what was the decision-making process really, I mean by that, and then why do we say the public body's decision or act was unlawful? So these are the sort of key questions that we will, as lawyers, have in mind, and that for you as advocates, it may be helpful for you to know that these are the things that we will probably want to be looking at. We might not expect you to be able to answer all of them, but things like who made the decision and when was it made, how was it made, what is the impact, you can probably provide a lot of help to us, and they will feed into the question then of why is the public body's decision or act unlawful. So just returning to that last question, why is the public body's decision or act unlawful? What judicial review can't do, a court can't say, we would have made a different decision, we don't like this government policy, or this decision by a local council to close a library, or this decision by the NHS to close this maternity ward. The court can't just overturn a decision because it doesn't like it. What we have to do as claimants and lawyers acting for claimants is explain why the decision is unlawful. And there are some broad grounds of judicial review under which we can make those arguments. There's a fair bit of overlap between those grounds, and I probably am talking at a fairly high level of abstraction here, looking back at these grounds, and I'll go into a little more detail on the following slides. But when I was starting as a public lawyer, I remember someone very senior saying to me that the essence of judicial review of public law is really, if it smells wrong, if it feels like an injustice, then go to a lawyer and there may well be a judicial review there. So if it smells wrong, if it feels like your client or others are being treated unlawfully by a public body, then speak to a lawyer and we can try to fit it into one or more of these grounds of legal challenge and advise you whether it's possible to do that. So the three main grounds of judicial review, as I said, there are three which can overlap. First of all, procedural unfairness. That's the process leading to the decision was unfair. And I'll go into some more detail about why that may be. Secondly, illegality. The public body acted outside its legal powers. Thirdly, irrationality, where the decision was so unreasonable that no reasonable decision maker could have made it. Now that's a high bar, and it's intended to be because judicial review isn't supposed to just be about the merits of a decision. It's not for the courts to overturn decisions because they don't like them. Like I said, it's where there is a public law, a legal error in the decision-making process. So it's more about the process of the decision, or whether the body making it had the power and acted within the powers it has set by Parliament. So just, I think, drilling down into that a little bit more. Oh, sorry, there's one more slide here. And a decision can also be challenged on the basis that the public body's acted in a way which is incompatible with human rights as protected by the Human Rights Act. One thing to note there, though, that in relation to primary legislation passed by Parliament, the courts can't overturn primary legislation. So if Parliament passes an act of Parliament, the courts can't overturn that. The most they can do is declare it to be incompatible with one of the rights protected under the Human Rights Act. That's very rare, but it can happen in limited circumstances. What the courts can do, however, is overturn secondary legislation, such as regulations made by government ministers. And a lot of law is now made in that way as secondary legislation. So, for example, the Welfare Reform Act will give the Secretary of State for Work and Pensions powers to make regulations in a number of areas relating to welfare benefits. The Secretary of State has to exercise those powers lawfully, and if there's an argument they have acted outside their powers or used their powers improperly, then a challenge can be brought through the courts by judicial review to those regulations, and the court, if it finds in favour of the claimant, may well overturn those regulations or say that declare that they're unlawful. Just a bit more detail and some examples of where a decision may be procedurally unfair. For example, if a public body has a duty to consult before it makes a decision, but it fails to do so, or it carries out an inadequate consultation, and I'll look at this a little bit more in the next slide, where the public body breaches duties under the Equality Act, such as the public sector equality duty, which is the duty to have due regard to the need to reduce discrimination. Essentially, there's a little bit more detail to it, but it's section 149 of the Equality Act. Failures in the Care Act assessment process, for example, for a person with social care needs, if there could be procedural unfairness there. Could be a failure to follow guidance, statutory guidance. A public body will need good reason to depart from statutory guidance, which it's supposed to follow when it's carrying out its role. And then some examples of illegality as well, misinterpreting their legal powers or duties or misapplying them, applying an overly rigid policy when they don't need to do so, using a legal power for an improper purpose. And when we talked about prorogation and Boris Johnson, that's really what the Supreme Court found. So Boris Johnson as Prime Minister had the power to prorogue Parliament between parliamentary sessions, but he acted outside of the limits of that power. Either he misinterpreted the limits of that legal power or he used it for an improper purpose, and probably a bit of academic legal debate about exactly what the right outcome is there. Illegality, failing to take into account relevant considerations when making a decision or taking into account irrelevant considerations. So that's quite a frequent ground of judicial review as well. Just on consultation, because a lot of cases do hinge on whether the public body has carried out a lawful consultation. For example, the NHS Act has a lot of duties on NHS bodies to consult when they are either reconfiguring or changing or withdrawing services. Local authorities often also will have a duty to consult before they withdraw or change services that a number of people benefit from. And the courts have held that in order for a consultation by a public body to be lawful, these are the four key requirements. So a consultation must be carried out when proposals are at a formative stage, so before a decision's been taken. The consultation must give sufficient information about the proposals to allow people responding to consider them intelligently and respond to them. Thirdly, the consultation must provide adequate time for people being consulted to respond. And fourthly, the public body must conscientiously take into account the results of the consultation, so people's responses, before taking a final decision. So I just flagged that because a number of judicial reviews do hinge on whether a lawful consultation has been carried out by a public body before making a decision. Now, remedies, what can the court do? Importantly, the court has quite a lot of flexibility to decide what it should do if it finds that a public body has acted unlawfully when a claimant brings a judicial review. So here you'll see it can make what's called a quashing order, which is to overturn or undo the decision being challenged. So effectively, the decision didn't happen. It had no legal effect. It can make a prohibiting order to stop a public body doing something, taking an unlawful decision or action, which it hasn't yet taken. And I'll give some examples of these when I come to some case studies later on. It can make a mandatory order. This is a bit rarer, but a mandatory order to direct a public body to do something. For example, to make a new decision. That might be to carry out a new social care assessment for someone, for example. Courts can issue a declaration, so declare that something a public body did was unlawful. And just on that point about declarations, although that doesn't necessarily undo the decision, it can be a very powerful outcome for an individual or a charity campaign group bringing a judicial review, because it can vindicate their legal rights and say publicly to the world that what this public body did was unlawful and that person was subject to an injustice. And that may be a source of embarrassment or public shame for the public body. They don't want a declaration that they've acted unlawfully or breached someone's human rights, even if that doesn't, strictly speaking, require them to do anything else. Declaration of incompatibility is a specific type of declaration under the Human Rights Act where, as I mentioned before, an Act of Parliament breaches the rights protected by that Act. They're very rare, but something that the courts do have the power to give. And likewise, damages, financial compensation for unlawful conduct is rare in judicial review cases. There are limited circumstances in which you may seek damages, but it's a possibility as well. The courts have flexibility. So I realise I've probably gone over my 25 minutes already of what I planned to say about judicial review, but I'll try and get through to the case studies a bit more quickly.
No, you're doing great. Keep going, Oliver. This is perfect. Don't worry about time.
Okay, great. Well, that's fine. Sorry, it's obviously if we were all in person, I could see everyone falling asleep or filing out of the room. So as it is, I'm just speaking to myself in a dingy basement.
Don't worry.
So the process of bringing a judicial review, I mean, if there's probably one slide which is the most important in this presentation, it's this slide. You must act quickly. Any application for judicial review must be filed at court promptly and in any event within 3 months of the decision being taken. So if tomorrow my local council decides that it's going to reduce the care package that I receive as a disabled adult, for example, from let's say 50 hours a week to 20 hours a week, or it's going to completely stop providing care to me. If it decides that today, then I need to bring that to the court promptly and in any event within 3 months. So if I'm outside that 3-month period, the court will say, sorry, you're out of time to challenge this decision. We can't do anything about it. Now, there can be some complexity to this. It's not always a hard and fast or obvious, this decision was taken on X date. And there is this concept of what's known as rolling judicial review, where in reality a public body is making a series of decisions on different dates. So while I wouldn't say this is flexible, it can be difficult, even for specialist lawyers, to identify the exact date which gives rise to this ticking clock. The lesson for you to take away is act quickly if one of your clients might have a case for judicial review, so that you can take it to a lawyer and they can advise if you need to be, or if the person should be making an application for judicial review. Now, the process of bringing a judicial review, what we as lawyers are doing once we have a client, an individual who's come to us and said, I want to challenge this decision, or I think I've been treated unfairly or unlawfully here. So first of all, we're identifying the decision, what it is, what's been decided or done by the public body, who it was that took the decision. So who do we need to challenge? When the decision was taken, as I said, because that's very important for promptness, bring the case promptly, and how it was taken. So the decision-making process, was there a consultation? Was there a social care assessment? How did the decision maker go about taking it? And just going back to that promptness point, it is to bring the case promptly and in any event within 3 months. So if you make an application to court 2 months and 2 weeks after a decision has been taken by a public body, the court could still find that you haven't acted promptly, even though you're within 3 months. So it's case by case, but the requirement is to act promptly. 3 months is just an absolute backstop for judicial review cases.
Oliver, can I
so step one of this. Sorry, Kate.
Sorry, a question just coming, which is uber relevant to that last slide. So sorry to interrupt, but the question is, how does the 3-month time scale kind of fit with the idea of using JR as a last resource?
Yeah, I mean, an absolutely good point. And it's really difficult to answer that in the abstract. It's case by case, I would say. But the question I can see now is it taken into consideration? And yes, I think yes is the answer, that if a person makes a complaint and the local authority's considering that complaint for 6 months and then says, actually, no, we're not going to do anything about your complaint, then it's very likely that time starts running again from that final decision to do nothing about the complaint. Sorry.
Thank you. That's perfect.
It is a bit case by case, and there's not a hard and fast rule, and courts can make very harsh decisions on this. But yeah, it's taken into consideration, but it is a factor to consider. So step 2, I've put it as, but maybe this should really be step 1. How will the case be funded? And as I said there, the likely options are going to be legal aid, potentially crowdfunding or private funding. And I've talked a little bit about the costs of a privately funded judicial review where it may be unsuccessful as well. So I think I can think of probably, well, a small number of cases where I've acted on a crowdfunded or privately funded basis in a judicial review, but it's always very difficult to do that because you're advising your client that they may need to stump up, a significant amount of money to the defendant, the public body, if the case is unsuccessful. And then the third, step 3 here, I've put the pre-action stage. So this is really where we're getting started on the legal work. And the first step, which we're required to do in a judicial review, is send a pre-action letter, also known as a letter before claim or a letter before action, to the defendant public body, setting out the facts and the legal arguments why we say they've acted unlawfully, in summary. And they're required usually to provide a response to that within 14 days, either to say, yes, we hold our hands up, we've acted unlawfully, and we will do X to rectify that, or no, we don't accept we've acted unlawfully, go away, effectively. The latter's more often a response that we receive, but it depends on the case. So that's pre-action. We send a letter notifying the defendant. This is obviously before making application for court, and the defendant provides a response. Then at that stage, we have to consider that response and whether we still have a strong case, whether we want to make the next step, which is the application to the court for permission to bring judicial review. So this is when I talk about the requirement to act promptly. This is where that kicks in. This is where you make the application to the court, and it's called an application for permission to bring judicial review because this is the first hurdle where the court can weed out what are considered to be unmeritorious cases. And I'll explain that on the next stage, but this is a unique to judicial review, unlike other court proceedings, that you need to apply to the High Court for permission to bring your judicial review. You may also at this stage be applying for what's called interim relief if urgent action is needed, such as an injunction to prevent a public body from doing a certain thing or require a public body to keep doing a certain thing until the case is heard by the court. So at this stage where you apply for permission, the claimant files a statement of facts and grounds, and that will expand on what has been said. Sorry, that will expand on what's been said in the pre-action letter, setting out all the relevant facts and the grounds of legal challenge for the case. We file that statement with the application for permission. And we might also file a witness statement by our client setting out what happened to them, what the impact is on them, etc. Then within 21 days of doing that, the defendant public body files what's called its summary grounds of defence. and that's where it sets out its legal arguments and anything it wants to say about the factual background. And then after that, the papers in the case, so everything that we as the claimant have filed and everything the defendant has filed, are passed to a judge to consider. I'll just start to speed up because I've just seen what the time is. So when the judge is considering whether to grant permission, he or she is considering whether the case has arguable grounds. That's the hurdle. If the case has arguable grounds, and that's supposed to be a low threshold, then the judge will grant permission for the case to proceed to a final hearing in the High Court. And within 35 days of that decision to grant permission, the defendant files more detailed grounds of defence. I should say these time limits can be shortened if there's a need to do so because of urgency. So you can apply for expedition of a case in the right circumstances. I've put step 5A there. If permission is refused by the judge who's considering the papers, the claimant has a right to apply for an oral hearing, what's called a renewal hearing, for that to be reconsidered. And I have acted in a number of cases where the first judge, just looking at the papers, has said, no, I don't think there's an arguable case. Then we've applied for an oral hearing. We've persuaded the judge that there is actually an arguable case. And then we've gone on to win the hearing, the final hearing. So judges aren't infallible. They're human just like us, and they can make incorrect decisions or they can disagree with each other even. So once you're granted permission, then you can proceed to a final hearing, which is where the parties make their legal arguments in court, usually for one day, sometimes maybe 2 days in particularly complicated cases. As I've said there, oral evidence from witnesses is very rare because judicial review isn't about a dispute about facts of what happened. It's a dispute about legal duties and powers. So it's really a case where the barristers are in court making legal arguments, and you as an advocate or your client are very unlikely to have to give oral witness evidence. There might have been a witness statement, but very unlikely that you'll need to give oral witness evidence. Judges in judicial review cases won't normally give their judgment on the day of the hearing. They'll usually do what's called reserve judgment and hand down their judgment at a later date, some weeks or months later. And then after you've got that judgment, the lawyers then have an argument about costs. And as I said earlier, the usual rule is the losing party pays the winning party's legal costs. And in the judgment, the judge will say, obviously, which party they're finding in favour of. So either the defendant has acted unlawfully or they haven't. And then they'll also say, what remedy, what relief they're granting to the claimant if the claimant has been successful. Step 8 and 9 here are steps that hopefully you don't have to consider, but that you can appeal if the case is unsuccessful in the High Court. You need to apply for permission to do that, to appeal to the Court of Appeal. You'll only get permission to appeal if there's a real prospect of success or another compelling reason, public interest reason potentially for the appeal to be heard. And then again, if you're unsuccessful in the Court of Appeal, you may apply to appeal to the Supreme Court. Very rare that cases go all of that way, but they can do if there's a difficult point of law, a novel point of law, or maybe if it's particularly politically contentious, as in some of the Brexit litigation, which, as I said, did go all the way to the Supreme Court. So if the case is successful, which hopefully it will be, then winning in court will usually mean the decision is overturned. Not always, as I said, the court may just make a declaration. It will very much depend on the facts of the case. But we'll want to be arguing as lawyers for the claimant that the decision should be overturned. One important thing to note, and a limitation of judicial review, means that doesn't stop the public body trying to remake the same decision later down the line, months or years down the line if it wants to do so. So if a local authority wants to close a library but has been told by the court you made this decision unlawfully because you didn't consult all the people you should have done in a lawful way, then 6 months later it may still try and close the library, but following a lawful process. So you may end up bringing more than one judicial review on the same issue. Sometimes we have had campaign groups which have challenged the same decision or different versions of the same decision more than once. And a very important point to note is the vast majority of judicial review cases settle a long way before they reach a hearing in the High Court. Very often after a pre-action letter sent to a defendant, so before you even made application to the court, or you may then make an application to the court if the defendant hasn't backed down following your pre-action letter, and then the defendant knows you're serious once you've made the application to the court, and it may then back down at that stage, or when the court grants permission because the court has said you've got an arguable case, and the defendant then may reconsider. So I've got some case studies. I've also only got 8 minutes, unfortunately, and I did say I'd leave some time for Q&A, so I've obviously failed in my duty there. But I've got a case study of an individual social care challenge, a local consultation challenge, a local Equality Act challenge, and a national policy challenge. I'll run through them very quickly, just so you have some examples of cases. The first 3 are cases I've run, and the last one is my colleague, Oliver Studdert, who's a partner in my team. So the first case was for a young woman called Laura. That wasn't her actual name, but it's her name for the purpose of this presentation. As you can see, a 22-year-old woman with autistic spectrum disorder and learning difficulties. She lived with her parents and needed support with personal care, day-to-day tasks. The reason there's a picture of some cupcakes with Laurel and Hardy on them there to illustrate this slide is that Laura was obsessed with Laurel and Hardy, that they were her one true love, I think. And after our case was successful, on her birthday, Laura's mum sent me this photo of the cupcakes they'd made together to celebrate her birthday. So that's what always reminds me of this case. What happened to Laura was, after a reassessment of her social care needs, the council, her social worker, effectively, or the social work team, decided to reduce the amount of support she received each week from 20 hours of support to 8 hours of support per week. And that's when Laura and her parents came to us to ask us to challenge that. Laura was eligible for legal aid, so we applied for a legal aid certificate and were granted one. And we sent a pre-action letter to the council to challenge its failure to lawfully assess Laura's needs and produce a lawful care plan in accordance with the Care Act, which many of you will probably be familiar with. With help from Laura and her mum, in that letter, we set out in detail the support that Laura needed and why she needed it. And her mum was her litigation friend. And following that pre-action letter, the council agreed to reassess Laura's needs. And after it did that reassessment, it provided an amended support plan, which basically reinstated and in fact slightly increased the amount of support Laura had been receiving, up to 15 hours of direct payments per week for care and support with community activities, and 6 hours of enablement support, which Laura and her mum were very happy with and allowed her to sort of get her life back on track and thrive. And as you'll see from that last bullet point, she started a work experience scheme and a cooking life skills course, and it was just a very positive outcome without needing to go to court in that case, because it was resolved following a pre-action letter. I've summarised it and condensed it, but we didn't need to make an application to the court in that case. The second one is a case that I worked on when I was based in Birmingham a couple of years ago, where we acted for Jane, again, not her real name because she was anonymised for the purpose of the court proceedings, but she was one of about 70 to 75 people who used a day centre in Birmingham, in Kings Norton. Jane has cerebral palsy and attended 4 days a week. There was a community of a lot of people who knew each other for years or decades who'd been attending the same day centre. But Birmingham City Council decided to close the day centre, but crucially without having properly consulted the people who used the day centre or their families before taking that decision, despite it saying to them, the council saying to them that it would carry out a consultation, hadn't taken a final decision, but then it changed and the council did say, no, we're going to close it. And you can see in that picture some of the people who use the day centre and family members as part of their campaign. I think they're outside Council Hall in Birmingham there protesting the decision. So Jane and her family came to us. We, again, got legal aid for Jane. She was financially eligible. We sent a pre-action letter to Birmingham City Council explaining in great detail how they acted unlawfully in not carrying out a consultation or a proper consultation with the people who are using the day centre and their families. Birmingham Council refused to back down, so we filed an application for judicial review with the High Court, Administrative Court. We also asked the court for interim relief. So Jane and some of the other people had got the impression from the council that they were going to close the day centre urgently in the very near future. So we applied to the court for an urgent order to prevent the council from taking any steps to close the day centre until the court had heard the case, had a hearing, and until the court proceedings had concluded. The court granted that order for interim relief at the same time as granting us permission, and the judge in the order effectively told the council to reconsider. The judge said, I'm granting permission because there's an arguable case and the claimant's case appears to be strong, so I want the council to reconsider this, or take external legal advice effectively before deciding whether it defends this case, which is quite a clear message from the judge that he thought the council was going to lose when we got to the substantive final hearing. So that newspaper headline there is from when that interim relief order blocking the closure of the day centre temporarily pending the court proceedings was made. And then following that order, what the council did, so still on this one, that the council then backed down. I think what probably happened was the council's internal legal team went to an external barrister who said to them, what are you doing? You've clearly acted unlawfully here. You need to get yourself out of this and stop this. So the council conceded the case and agreed that it wouldn't close the day centre. The third one was a case similar in some ways concerning a soup kitchen in Walthamstow, which had been using a publicly owned car park for a number of years. And the council there decided it didn't want that soup kitchen in the car park anymore. So it said, you can no longer use this car park, which we, the council, own. Here's an alternative site for you on a busy A road. Now, given that the people who were using the soup kitchen, around sort of 70 or 80 people a night, many of them were vulnerable, many had disabilities, some were elderly. You can imagine why the side of a busy A road may not be a suitable place for a soup kitchen operating from a van to operate, unlike a car park in the centre of a town. So we challenged that decision. We got legal aid for two individual users of the soup kitchen, Teresa and Marlon, and for the charity which ran it, a Christian charity called Christian Kitchen. So we didn't have legal aid for the charity. We acted pro bono for the charity. We weren't paid by the charity, but we were funded by legal aid for the users of the charity. And in that case, the court found that the council, when taking its decision to stop the soup kitchen using the car park, hadn't complied with the public sector equality duty, which is, as I said, to have due regard to the need to advance equality of opportunity, reduce discrimination between people with protected characteristics under the Equality Act, such as age, disability, race, etc. So in that case, the court quashed the decision to to stop the soup kitchen running from the car park that it had run from for many years. Final case, which is ongoing at the moment, as I said, one of my colleagues bringing it against the government, the Secretary of State for Education, concerns regulations made during the COVID pandemic, which remove or dilute safeguards for children in care. And it's brought by a charity called Article 39, which many of you may have heard of. And it concerns that statutory instrument, those regulations made by a government minister called the Adoption and Children Coronavirus Amendment Regulations. And our case there is that we say the Department for Education failed to carry out a lawful consultation before bringing in those regulations. And Article 39 say that the changes are a disproportionate response to COVID-19 and significantly increase the risks to vulnerable children in the care system. Now, in the High Court, we were unsuccessful. The judge found, largely because of the national crisis of such urgency, that the consultation was not unlawful in the circumstances. One of our grounds was that the Children's Commissioner hadn't been consulted by the Department for Education, neither had any children's rights charities or advocates. The only consultation was given essentially to care providers, people providing care for children, rather than people concerned with protecting children's rights, such as the Children's Commissioner. So the High Court found against us, but we were granted permission to appeal to the Court of Appeal, and that appeal was heard in September last month, and we're waiting for the Court of Appeal judgment. So watch this space on that one, but I thought I'd include an example as well of a challenge to a national policy to regulations where, although so far it's been unsuccessful, we're continuing our challenge. So sorry for having used 1 hour and 2 minutes rather than, as I planned, more like 40 or 45 minutes for my talk. You can never trust a lawyer to keep to a time estimate, but Q&A if we have time, Kate.
I'm happy to stay if you are. And
I'm happy to stay. My social calendar isn't exactly packed at the moment.
Don't believe you, but that'd be great. Yeah, and then people can stay if they like. Excellent. Thanks, Oliver. Right. So there were 2 questions in the chat box that aren't in the Q&A. So if I mention these first, one was an interesting one around when you were saying about JR can't be used to overturn primary legislation, where it can comment on whether it's incompatible, I think was the phrase. Yes.
With the Human Rights Act, yes.
Human Rights Act. Does that kind of tie in, this discussion on the UNCRPD not being compatible with the Mental Capacity Act, not being compatible with the UNCRPD because of this distinction of, in the Mental Capacity Act, you just have to have regard for a person's rights, but you can basically dismiss them, whereas the UNCRPD demands that you respect. Is this, I think, sorry, I'm going on here. It was a long question, but yeah. So the person's asking, can JR be used to challenge that?
Yeah. So I mean, this is a little bit tricky because the UNCRPD hasn't been brought into domestic law, as I understand it, in the same way that the European Convention on Human Rights has been by the Human Rights Act 1998 was allow courts in the UK to make judgments on rights protected under the European Convention on Human Rights, rather than requiring people to go to the European Court of Human Rights in Strasbourg to get those judgments. So that was the benefit of the Human Rights Act. Effectively, it brought those European Convention rights into UK domestic law. So that's where the difference is, and that's not to say that we as lawyers and claimants can't make arguments about treaties which the UK has signed up to in international law, but it's a different process where they haven't been specifically incorporated into domestic law.
Got you.
And there are technical, academic, legal arguments about that, which I'm probably not able to speak about at the moment.
All right, fair enough. Then there was a question around when should you mention / threaten JR as opposed to actually doing it? So
well, I mean, sending a pre-action letter is a threat of judicial review. Effectively, that's, and you don't need to have lawyers to send a pre-action letter, but given the technicalities of the law, then probably it will be best for a lawyer to draft one. But but I suppose if you're an advocate, is the question there sort of where I think one of my clients has been treated unlawfully? Shall I talk about judicial review at that stage? Or maybe you're better sort of tactically just saying, well, I want to get my client legal advice on this, which is sort of a read between the lines way of saying, I might be looking at getting advice on a judicial review here, because, ultimately lawyers will need to advise on the case, will need to get legal aid in place if the person's eligible. So I suppose just tactically don't over threaten beyond where you're at.
Yeah, I think that's great advice, because there's so much power, isn't there, very politely saying, oh, I think I might get legal advice.
Yeah, exactly.
Yeah. Right, okay, I'm going to just go to the Q&A because there's a couple of really good questions there. So first question was, can an individual case be widened to make a wider change if under legal aid?
Yes, absolutely. So, I think this talk was titled "Using Judicial Review for Systemic Change," and I tried to sort of incorporate that by saying, while a challenge might be brought by an individual person, depending on what decision or policy the challenge is against, it can have a much wider systemic effect. So if you're challenging government regulations, they may be affecting tens or hundreds of thousands of people or more. If you're challenging the closure of a day centre or a soup kitchen, that may affect dozens of people or more. Or a social care policy which a council brings in might affect thousands of people in its local area. So but the legal challenge itself may just be brought by one of the people who's affected by that, but the outcome may affect hundreds or thousands or limitless people potentially.
Yeah, thank you. Interesting question from Jane. Do you know of any data, kind of what percentage of JRs are successful?
Yeah, so I mean that's tricky because so many are resolved before they ever get to the court.
Yeah.
So as I said, the government is now carrying out a review of judicial review, effectively, of administrative law. And we've just provided a response to that, as have a number of charities and other people concerned with judicial review. The statistics show that I think it's around 3,500 applications for judicial review are made to the court each year. And of those, only around 200 or so reach a final hearing. Okay. And once you get to a final hearing, around 40 to 50% are successful for the claimant. But that's 200 out of 3,500 per year, which are made as applications to the court. But then even before that stage, we don't know how many pre-action letters are sent. So, and there aren't statistics on that. But in my experience, I would say something like 60 to 80% of cases are successful in some way, in the sense of getting the outcome that the claimant wants. But whether that is at the pre-action stage before you ever make an application to the court, whether it's after the court grants permission, whether it's following a final court hearing, it is difficult to say. But
there's no like publishing.
Very often, in my experience, yes, you do get tangible benefits from it.
Thank you. I think you may have answered this from Siobhan, but she says it's a big risk for someone privately funding or even crowdfunding if you've got to pay defendants' costs. Is there any way to indemnify against this?
Yeah, Siobhan's right. I can see that question. Surely it's in the public interest to hold public body decision making to account. Absolutely, and that's a key point that we've made in our submission to the panel considering reform of judicial review. In terms of indemnifying against paying the other side's costs, it is possible to apply for what's called a protective costs order to limit the potential risk, but they're only granted in narrow circumstances, normally where there's a public interest in bringing the case, a wider public interest in bringing the case. That's something that we or other public lawyers can advise on in individual cases. I didn't go into the detail today, but it's possible but rare to get what's called a protective costs order. One of the things that we have argued in our submission to the government about reforming judicial review is that for people who aren't eligible for legal aid, it is really inaccessible. It's practically impossible for people to access judicial review because of that risk of having to pay the other side's costs. So we've argued that the presumption should be that the claimant doesn't have to pay the defendant's costs if the case is unsuccessful. I think it's unlikely the government will agree to that because the government and other public bodies probably find it inconvenient to defend judicial review cases. But obviously, as a lawyer representing claimants, I think it's very important that all public bodies are held to their legal duties and are accountable to the law. And if it's practically impossible or very difficult for people to actually bring those cases unless they're eligible for legal aid, and we know that legal aid has been cut significantly in recent years, then you get decisions which are taken unlawfully but which proceed uncorrected because no one's able to challenge them. So there is a real access to justice issue there, and it's something I'm very passionate about, but it's a difficulty with judicial review. But I would say, as advocates, where you think there's been some unfairness or a decision that's unlawful,
lawyer.
speak to a lawyer and they can talk to you about possible funding options.
That's definitely the message being communicated yesterday and today. Speak to a lawyer, don't wait, get advice, yeah. Jane's asked another question about when a local authority chooses not to follow statutory guidance. And the example she's given is children's advocacy and child protection processes. Jane just chuck in the comment box, what are you thinking there when they kind of age limit it? Which is weird, isn't it? They say child protection advocacy for children aged 8 and above. Well, what about 7-year-olds? You know, can they not? Why is it different? I don't know. But I think the question is what's an acceptable reason? How do they justify that? Well, Jane said, okay, sorry.
Yeah, I think it's a bit difficult to answer in the abstract, but the broad answer is that a public body, including a local authority, needs to have a very good reason not to follow statutory guidance. That will depend on the case and depend on its justification for not doing so in the circumstances. So I think I'd struggle to sort of say in the abstract, whether I could give an example. I suppose an example would be if by following the statutory guidance, they would be creating an injustice to the individual in some way. But, statutory guidance is there for a reason. It's there to be followed unless there's a good justification for not doing so. It does have to be a good justification.
Got you. And would finances, i.e. they can't afford it, would that carry weight?
No, that's not a good reason.
Okay. Right then,
that might be a reason why a local authority needs to challenge the government itself for not funding it. And what I didn't say is that public bodies themselves can be claimants in judicial review proceedings against other public bodies. There was a challenge, for example, several years ago by a number of local authorities challenging the lack of funding they received from central government. So they brought a judicial review against the Secretary of State for Health, I think Health and Social Care, for lack of funding for them to comply with their duties under the deprivation of liberty safeguards.
Oh, that's right. It was Staffordshire.
Liverpool City Council were one of them. There are a number of other councils. The case was unsuccessful.
Yes.
And actually, I think it was an example of a case where, although it had been brought within 3 months, it wasn't considered to have been brought promptly, partly because the claimants were all local authorities, so it was sophisticated claimants with access to legal advice. But they were effectively challenging the central government's failure to give them proper funding. So, local authorities, public bodies can't say, we didn't do this because we don't have the resources. No, if you've got a legal duty to do something, you do it. And if you don't have the resources to do that, that's for you to take up with central government effectively.
Got you. Thank you. Quick one around time complete. I think you might have covered this. So I don't know if you can see the Q&A. So if it's likely to take more than 3 months to run a complaint, does the time taken from ombudsman take into consideration? I think you said it is, but get legal advice.
Yeah, I mean, this is complicated, and different judges can take different approaches to this. But for example, I was in court on a case yesterday where the public body making the decision, which was the Independent Office for Police Conduct, said it had made the decision on a date in September 2019, but it had only sent a letter to our client about that decision in November 2019, and then the decision itself was only sent to us in February 2020. So there are 3 potential dates there for time to start running. And when we made an application to the court, I think in April 2020, 2 months after we received what was the actual decision, the Independent Office for Police Conduct said we were out of time to challenge it because they made the decision back in September. And we said, no, this is when you provided it to us. We explained to the court what the time frame was, and the court agreed with us that we had brought it in time. That's not to say all judges would have agreed in those circumstances, but clearly it would have been a gross injustice to our client if they hadn't been notified of the decision until November, but the public body was saying, we made it 2 months before or 6 months before.
Yeah, that makes sense. And you've beautifully answered Christine's question about is the date of the date of knowledge considered. So
yeah, I mean, strictly speaking, it is the date of the decision, but the court will take into account what the date of knowledge was.
Yeah.
And we will argue, of course, that if we didn't know about the decision until January 2020, how could we have challenged it in June 2019?
And I think, wouldn't it be interesting in COVID, when things kind of ground to a halt, and the Ombudsman, for instance, they've said the usual 12-month limit, they were going to be flexible with that because of COVID. Yeah. Okay. Interesting question around advocates acting as litigation friends. And do you have any thoughts on the benefits of advocates being litigation friends rather than official solicitor?
Yeah, so in judicial review cases which I've brought, I don't think I've ever had the official solicitor as a litigation friend. It's always been either a family member or an advocate, either a sort of formal or informal advocate. But I've had a lot of court of protection cases where the official solicitor has been the litigation friend. And I think that's, the reason for that is in court of protection cases concerning an adult who lacks capacity, the family members will often be separate parties and may have separate cases to put to the court. Whereas in a judicial review, the individual and their family are arguing for the same thing effectively. So a family member is more able to act independently as a litigation friend in a judicial review where they're not a party, where it's individual against public body. Whereas in the court of protection, you've got individual, maybe several family members, one or two public bodies. So that, I think, is why there's a difference. In terms of me acting as a lawyer and who the litigation friend is, experience of, like I said, family members doing it, advocates doing it, the official solicitor doing it, it's different, and it affects how you as a lawyer communicate with the litigation friend. But completely flexible and happy to do it in whatever way.
Got you.
I don't know if that answers the question. I hope it does.
Yeah, I think so, and I think that's I think that probably reflects what.
And I suppose if an advocate is doing it, it's as part of their role to give voice to the person, to speak up for them, and also act as a kind of conduit, I suppose, between the lawyer and the person themselves, where the person doesn't have capacity to instruct a lawyer.
Yeah. And then Claire, there's a follow-up question around, is there any way to get good information about litigation friend?
So that question I can see asked about the liability a litigation friend may have. I have advised on that in the past, and the advice we've given to people acting as litigation friends is that while technically the court would have the power to make a cost order against them, we're not aware of any cases where that's been done. And we think that would only be done, I think, where a litigation friend had acted improperly or brought vexatious litigation on behalf of someone, for example. So it's very unlikely that liability will arise for a litigation friend, but we can't say it's 100% impossible. We can just say we've never come across it in decades of bringing judicial review cases and often acting for people with litigation friends. But I can advise, individually on that in individual cases.
Thanks, Oliver. That's great. And if I can just kind of refer people to our wonderful friend Peter Edwards over at Peter Edwards Law, he does some really good training, and one of the courses he does is about litigation friends. And tomorrow. So just to give a plug to him, because he does training. 2 more to go, Oliver. Are you there? You still with us?
I'm here.
Woof. Look at this. 2/3 of people are still with us. You're amazing. Okay, any cases where NHS and CHC, look at all these acronyms, has been removed unfairly, so challenging that?
Yes. I mean, I can expand on that, but the answer is yes. I've done those cases. Colleagues have done those cases. I've not had one that recently, actually. The circumstances in which continuing healthcare has come up in some of my cases more recently has been where I've been acting for someone who's receiving social care from a local authority, but there's an argument that what they actually have is a healthcare need, and therefore applications made for continuing healthcare funding. So I've had 1 or 2 cases which have been resolved that way, really, by the local authority saying we're not the public body that should be funding this. It should be the NHS through continuing healthcare. But yes, where someone is assessed for continuing healthcare and it's refused, or the assessment or the care plan isn't thought to provide enough support for them, then that can be challenged by judicial review. Yes.
Got you. So that's encouraging. Thank you. And does the local authority fund? Oh, this is interesting. JR brought by looked after children.
I think we asked them to in the past, but I would expect a looked after child to be eligible for legal aid, unless they're not going to have an income, or it's very, very unlikely they will, significant income, and it's unlikely as well that they would have significant savings to take them outside the threshold for legal aid. So it's £8,000 in disposable capital is the threshold limit. So I think there have been occasions where we have asked certain public bodies to fund legal advice for looked after child or a person in their care, essentially for another reason, but I'm not aware of a judicial review that we've acted on being funded by a local authority. It's not impossible, but I think it's, you probably need quite exceptional circumstances for it to do so.
It's uncommon.
But if the looked after child wasn't eligible for legal aid, then maybe an argument could be made that the local authority should exercise its discretion to fund legal advice for them.
Yeah. Thank you. Now, Stephanie, I know you had your hand up earlier, so I've unmuted you. If you wanted to ask a verbal question, please do. If you just knocked your hand on back, then don't worry. Easily done. Okay, I'm going to assume that there wasn't a question then.
Okay, great.
Great. Okay, Oliver, thank you so much. You've gone above and beyond there. With your question. You're exhausted, yeah. Whew.
Well, yeah, I'm sorry I spoke for so long. I really thought I would be closer to my time limit.
No, it was excellent, and thankfully we're at the end of the day, so we could run over. So, well, it wasn't run over.
If there's one message, for advocates, if in doubt, do speak to a lawyer and have that initial email or phone call with this is what's happened. What do you think? And we might say, go to the local government ombudsman, or we might say, oh, this is worth looking into.
Yeah. Great advice, and that's definitely the leaving thought for the session. Yeah, that's great. Well, lots of thanks in the chat box, and really well attended session. So thanks again, Oliver.
Well, thank you very much.
Thank you.